Hello everyone, welcome back to my channel. So today we are going to talk about administrative law in brief, as this is just a demo lecture. So details will be discussed in actual course. So I'll be sharing all the details of the course, how I take the lectures, about notes and everything. So do not miss this lecture. This is really important. You will get a complete idea on what is expected from you while you will be writing your NCA administrative law exam. So without wasting further time, let's delve into this lecture. So before beginning with our demo lecture, I would like to discuss first all the topics that are there in the syllabus of admin law. So there are 13 topics and these are my notes. So first is setting the stage, the very basic, the big picture, the base introduction you can say. Then comes the main topics, procedural fairness. So there are total 8 topics under this: sources of procedural obligation, then triggers, and then we have content, that like right to be heard, unbiased independent decision maker, and then any issues arising from institutional decision making. Then comes the next part, substantive review. So here comes the Vavilov test, standard of review, and last is how do you challenge. If some administrative authority has made a wrong decision, how do you challenge that decision? So where you will have to go, whether you will go for judicial review, whether you go for standard appeal. So venue, basic procedure for judicial review, and what are the remedies you have. So this is your simple 13 topic syllabus, and then these are my notes just to give you a glimpse. And then now in my recorded lectures, I have also started providing students some additional things, some visual representations to make lectures more interesting. And then we have flow charts and side by side answer writing practice. So these are the notes you can see. So whatever is important, like some kind of charter, some kind of paragraph that is important from the book, so I take those things directly so that you won't have to go for multiple sources. You can find everything under one roof. Like I've tried to put little bit of colors because I know these things make lectures, notes interesting. The visualization is really important. And then, so these are the cases. Everything is there. Like you don't need to go for any other source. Like I've highlighted main sections, the charter rights. These are all cases, indigenous ones. And then we have all the rights here, key takeaways, then important principles. So everything that you need in your answer. So you will find all the case laws in red font. This is the Vavilov test, main. Then challenging the decisions. And then towards the end, just to clear out your basic concepts, I have provided a few questions, practice questions here. Just short statement based, and there are answer hints here. And then fill in the blanks, true false with all the answers, and reasoning as well. Then I have to match the following. Then we have long practice question. Legal memorandum. This is very important. So here are few questions. This is very detailed, completely solved one. And then detailed decisions, Baker and Vavilov towards the end. Like these are complete judgments in case you would want to read. Although in the lectures we will definitely discuss the complete law word to word, but the students who are just buying notes, so this is for them particularly. So in 156 page, you are getting everything what you need to pass your admin law exam. So today we are going to discuss first half 50% of topic number 1 as per the syllabus that we just discussed. So setting the stage. This is the base of admin law. So let's read what syllabus says first. So one of the most important things to understanding studying administrative law is the big picture. So you can see I have highlighted here the important things. So this is how you need to analyze, interpret your syllabus word to word. Understanding syllabus by heart is really important rather than just jumping towards the notes or pre-structured answers. If you understand the syllabus, this one paragraph, so your first topic is done, because this has everything. You just need to understand, you just need to go into the core of keywords. So what does big picture means here? So by big picture we mean that before we jump into any cases, any rules, test, or even any technical words, we must first understand what administrative law is. So a failure to do so may result in candidates becoming lost in extraneous details. So before jumping into any technicalities, first let's understand what does administrative law mean. Because if you don't understand the big picture, the base, if you don't set your stage, then administrative law can feel confusing, overwhelming, and full of random rules. So students often get lost because they start memorizing details without knowing why those details exist. So this answer of why is very important. So today, before anything else, we have to answer this simple question: why does administrative law even exist, and what does this word administrative law means? So the core idea of administrative law in very simple words is that it is the body of law. Again, I have highlighted here. It is the body of law that governs how people exercising power pursuant to a delegation of power in a statute or occasionally the royal prerogative go about their businesses. So now you have read these 3 lines, these 2.5 lines in one reading, in one go. 50% of the students, I'm sure, won't be able to understand what is the core. So that is why here you need a tutor who can take you into the very heart, the very core of every word of these 2.5 lines. So now I am going to make it more simpler for you. So these 2.5 line means that administrative law is the law that controls. You can write down these keywords in your notes, in your syllabus as well, because these will be really helpful when you will be trying to interpret the problem question in your exam. So administrative law is the law that controls how government power is used. So once that power is delegated, is given to a government body, now administrative law comes into the picture. Administrative law governs and control how that government authority, government body can use that power which is given to it. But not all government power. So it is the only power So administrative law comes into picture only to those government powers which are either given by law to decision maker. So this law has further two categories. So one power, so this one law-making authority comes from statute. In simple language, we call act, which is passed by parliament or legislature. Sometimes this second power comes from royal prerogative, that is, old executive powers of the crown. Again, I'm emphasizing you can write down these words, write down these things in your syllabus, in your notes printout. That would be really helpful for you. Now the question arises, who uses this power? Who? So most of the time, this power is used by, let me have a clear slide here for you so that I can write down everything and you can note down side by side if you want. So we were at the question that who uses this power. So most of the time it is used by ministers, government departments, officers, boards, agencies, and tribunals. So who are these people? So these people are usually part of executive branch, but they are not often politicians. Sometimes they are independent from the government. So now the question arises, why do we even need administrative law? So here is the problem. So these decision makers affect real people's life. So their decisions affect, influence people's life. So that is why administrative law comes into picture to save people's life. Now I hope you're trying to relate. So try to understand, try to retain everything as a story. So what kind of decisions these authorities make? Sometimes immigration status related, professional licenses, some prison decisions, then social benefits, some environment approvals, labor, human right issues. So there are so many. Now, how do we make sure these decision makers use their power properly? So that is where administrative law comes into picture. So almost all the administrative law is about answering this one question only. What does properly mean when someone out of these people is using the government power? Which part? That we just discussed in our previous slide, that power which comes from law, and law means either statute or sometimes royal prerogative. So now I will take you again to the syllabus so that we can read out what we left behind. So in most cases, the people who have this form of power, again typically given to them by a statute, are members of the executive branch. We have already discussed that who can be those members, who are those people, like ministers, etc. In our system, based on the rule of law, we want to make sure that people with this power exercise it properly. So this is where we left our last slide. Almost all of administrative law is about deciding what we mean by properly. So this is what the examiner would expect you to decide, whether so and so authority, so and so delegated power has been used by that particular person or particular body, authority properly or not. So properly does not always mean that the decision must be perfect, The court must agree to it. So it does not mean this. Instead, what it actually means is, number one, was the process of coming to some kind of decision was fair? Number two, did decision maker stay within legal limits? Legal means whatever authority, whatever power was granted as per the statute, whether that decision maker, that particular authority, tribunal, body, any person, minister has acted within those authorized parts. Number three, did they act reasonably? Number four, did they follow the law? So this is important. The statute, the person has to follow the law. Which law? That statute, that law which gave that particular decision maker the authority to make that particular decision. So that power. So you can write down these four things, that what does properly here means. Now why chapter 1 is important? So chapter 1 of your casebook explains, number 1, why administrative law matters. Number 2, how it fits into the legal system. Number 3, basic structure of the subject. So you have to think chapter 1 as map before your main journey of administrative law. So without this map, the rest of the course feels disconnected. That is why this is really, really important. So this we have already discussed, that why chapter 1 is important. So in this syllabus, we divide the discipline into three parts. So three big parts of administrative law, very important. And while you will be preparing for this subject, every stage, at every step, you should keep on asking yourself which part of administrative law I am in. This would help you to write your answer perfectly without any confusion in your mind. So at each step, if you are studying some procedural expectations, ask yourself that okay, at which stage I am in, then answer yourself out of these three. So first is procedural fairness. Second is substantive constraints. Third is how to challenge administrative decision and what are the remedies you have, what are the solutions you have. So today we won't be going into much depth because you will feel confused. So this demo lecture is only to give you a broader picture, to boost confidence in you, because so many students come up to me with this query that we feel administrative law is boring, is tough. So there is nothing as such. I always say every subject is equally easy and equally difficult, because at the end you have to take every exam. You cannot skip any exam. You will have to pass every exam in order to be NCA qualified. So never think any exam as easy or tough. Just follow the right approach and you will be good. So coming back to our syllabus, procedural fairness. More generally, procedural expectation that administrative decision makers must meet. Then substantive constraints means sort of errors done by the authorities, decision makers while deciding the merits of a matter, which decision makers must avoid any kind of biases, discriminations. Then how do we challenge these decisions and what are the solutions, what are the remedies we have, what is the procedure to be followed in seeking those relief. So this is how you have to attempt your answer. So intro, then this will be your first step, second, third, and then conclusion. That's it. So admin law I personally feel is one of the easiest subject. Only your approach should be right. So I will explain you all these things today one by one. So number one, procedural fairness, or we'll write it PF. This is about how a decision is made. So like every decision goes through some particular process. So goes through some particular rules and regulations. There is a road. So for that decision, what road was followed? So how a particular decision was made? Was the person hurt? Was the process fair? Was the decision maker biased? So this concludes procedural fairness. So even if the final decision is allowed by law, it can still be illegal if the process was unfair. So keep this in your mind. Next is substantive constraints. What decision was made? So after going through a particular road, where you reached, so that destination where this road took a particular thing, was that right or wrong? So was the decision reasonable? Did the decision maker misunderstood the law? Misunderstood law. Did they misuse their discretion, their power, their authority? Last is, so sorry, I missed one thing. So this is where standard of review, because we are reviewing the final destination, comes into picture. The Vavilov test. Before this, we have Baker's test. Without these things, your answer is incomplete. So these are must. All other cases are additional, but these are the main base of your admin law. Last is judicial review. If you feel someone has taken you to a wrong path, you have reached at a wrong address, your destination is not correct, and someone has left behind you, there is no one to help you. Now you need to see, now you need to review, you need someone's help to reach the right destination. So this is where judicial review comes into picture. You first analyze that how I reach the right place. So how do we challenge the administrative decision? Which court do we go? And then comes into picture remedy. Once you are in court, you will see that what I need, what kind of remedy, what kind of solution, what kind of compensation I want. So here comes remedies. So can the court send the matter back, for example? Can it substitute its own decision? So these kind of remedies. So this was a broader picture and setting the stage for you. Whatever will follow this first topic is just the explanation of all these things one by one. But main whole gist of your complete admin law is this one slide. So at last, I'm going to draw a kind of flow chart. So this flow chart is a kind of exam ready answer writing thing. So this is the main structure base of your answer, and you would just need to fill up things. You would just need to analyze and back up your analyzation with analogous and contrary case law precedents, and you will be good. So we are starting with, at the top we have parliament or legislature, which makes the law. Now, here we will write what it does. It delegates power by statute. Now, to whom? To administrative decision makers, executive branch. And you can write down here ministers, government department, board, tribunals, which we just discussed previously. These people have to go by rule of law. So rule of law question comes into picture. And what is the question? Did decision makers use power properly? So this properly question comes into picture. Now comes three things. Here, procedural fairness, side by side, substantive constraints. When you go through these two things, it lands you to either judicial review remedies. So either here means either it will be a statutory appeal or it will be a judicial review. So one of these two things. And which court, who has standing. Then when we talk about remedies, you can also write down set aside decision, send back remittal, or substitute decision, which is rare case. So this is the main flow chart. So that was all about today's demo lecture. I hope you understood the big picture well. You understood topic 1, but my lectures are really detailed. So this was just a glimpse, just a highlight of what we discuss in the lectures. So usually my admin lectures are minimum 1.5 hour and maximum it sometimes go to 2.5 or 3 hours as well. And I divide like all my lectures topic wise. So if there are 13 topics, so straight away there will be 13 lectures, and then always one lecture on the sample answer writing, that is sample question provided by NCA itself, the official one. And then 1/15th lecture would be the revision lecture, where we will be reviewing whole syllabus, and I will be also guiding you for important case laws. And then if some student has some queries, some doubts, then we can always cater to those as well separately. Personally, if some student wants to get their answer checked from me, I provide that provision as well. So usually what happens is how I prefer teaching. So once we are done with syllabus, once we are done with the sample answer writing and then with the revision, then I give at least 5 to 7 days to students to do their personal revision once again, and then I start with the answer writing. So I assign answers and then students write down, prepare their flow charts, and then they send back to me. So I usually prefer not going by complete 3-hour answer. So it's your personal choice. So I prefer that whatever question I'm giving you in the answer writing practice sessions, just provide a good intro, conclusion, write down the rules, and then for the main analysis part, so in this IRAC thing, main analysis, just provide me the flow chart that okay, in this question, procedural fairness, this is the bias, this is where the decision making authority hasn't followed the process, and then substantive constraint, and then whether it is an appeal, it's a judicial review, and what would be the remedies, so that it saves your time and you can attempt as many questions as you can before the actual exam. So I prefer this answer writing practice with one-on-one checking and feedback at least 15 days prior to your exam, because this is really important. Rest, if you have any doubts, feel free to reach out to me at this email address. Thank you and have a good luck.